This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
The topic today is disinheriting minor or dependent adult children. And we're with Wes Mussio from Mussio Goodman. He's the managing partner there.
Thank you.
Can a parent disinherit his minor child or an adult child that is dependent on him?
The simple answer is very difficult to do because the way the law works is that there's a moral and legal obligation on the part of the testator or the will maker to provide for any infant children, so anyone under the age of 19, and also to provide for adult disabled individuals, because just because they get over 19 doesn't mean you can just throw them out on the street. You have to still provide for them as a legal obligation. So what it is you have a legal obligation to provide for these individuals because they need your help and assistance. So if you go to disinherit them, the court is almost guaranteed to overturn that, except under very significant or unusual circumstances. And even on top of that, you have the moral obligation, which means that you should be providing for all your children anyways, regardless of your legal requirement to do so.
What does the court look at to consider the disinheritance?
Well, what they do is they look at a number of factors, and there's quite a few factors, but they look at what the need is of these individuals. It would be a start, like financial need. They also look at the size of the estate, and they look at competing interests, so other children that are inheriting something, to make sure that there's some fairness to it. But ultimately, when they're looking at these dependent or infant children, what they do is they want to make sure that they're reasonably provided for their lifetime, and so that's the main factor that the court looks at.
Why can the court overrule the will and the desire to disinherit?
Well, the Supreme Court of Canada went forward and looked at the legislation in British Columbian, which is unique to most jurisdictions in North America, and it's a good piece of legislation. And what the legislation is that we have wills variation claims, and so the Supreme Court of Canada said, listen, testamentary autonomy, which is the will maker's choice and what the will maker wants, is secondary to the legal and moral obligation of the testator to his spouse or children. And so they look at exactly that, and they ensure that what the testator has done in his will would be something that the average objective individual deems reasonable. And if you have any further questions on this topic or others, feel free to reach out to me at my email, mussio@mussiogoodman.com, or give me a call at 604-336-8002.